Hello, I'm Jeff Smith, the author of New Horizons in Natural Cancer Therapies. Available on the website naturalcancertherapy.net. Now let's talk about what to do if your criminal defense attorney is selling you out. Public defenders and even paid attorneys are notorious for selling out their clients. When you're facing criminal charges, you have no assurance that your attorney is not selling you out and assisting the district attorney or state's attorney in winning a prosecution. If you learn how to do a little bit of legal research, you will discover that it is likely that your attorney is not mounting a vigorous criminal defense on your behalf. Let's look at some real-life examples. A woman who lives in California was charged with driving on a suspended license. The California Department of Motor Vehicles never contacted her and never invited her to come to a hearing, as required by the California Supreme Court and the U.S. Supreme Court. So the DMV is required to invite you to come to a hearing before they can suspend your driver's license. This is called notice and opportunity. Here's the case law on that subject. Rios versus Cozens, 7C 3rd 792, 103 Cal Reporter 299, 499 P 2nd 979. That's the California Supreme Court. This ruling was handed down in 1972. And there was a substantially similar U.S. Supreme Court ruling called Bell versus Burson, 402 U.S. 535. That's a U.S. Supreme Court ruling from 1971. Now, if you look up these cases, you will notice that the California Supreme Court decision was issued 1 year after the U.S. Supreme Court issued their decision. The California Supreme Court, in their ruling, fully recognized that they are bound by United States Supreme Court rulings. In Rios versus Cozens, California Supreme Court, 1972, the California Supreme Court has issued a ruling establishing a mandated procedure that the California DMV must at all times hold a hearing and give the holder of the California driver's license notice and opportunity to participate in a meaningful hearing before they can suspend a California driver's license. This woman's public defender attorney refused to include this ruling and the legal doctrine that is invoked in Rios versus Cozens by using a big lie. He said the case has been overturned, which is not true. This is an act by the attorney of selling out his client. There is no excuse for this. And this is unethical and immoral. It would be similar to paying an auto mechanic to repair your brakes, and he does not replace essential parts or does not adjust the brakes so that one side of the brakes wears out faster than the other. When an attorney refuses to give you a vigorous and aggressive legal defense, he is condemning you to jail time and heavy fines, even though you have a viable legal defense that they refuse to use in defending you. The question naturally arises, why are they doing this? Does the public defender have a secret agreement with their employer or the judge to make sure you lose the case and the district attorney wins? I know of situations where people were paid big money they paid out big money to private attorneys, and they were sold out by their attorneys. The best example of this is the case of General Michael Flynn. If you look into the details of the Flynn case, you will discover that General Flynn was pressured into pleading guilty so that his son would not be charged with a crime that the public prosecutor falsified. with the assistance and complicity of General Flynn's attorneys. This has been very well vetted in the media. I know of a high-profile case where the U.S. Attorney decided that a woman who was friends with a high-profile group of criminal defendants, did not commit any crimes, and she did not participate in any of the criminal conduct that these friends of hers engaged in. She was charged with the crime of stealing her own computer, which of course is not a crime. And her attorney did not advance a vigorous legal defense, but sold her out, and she did a short jail sentence as a result of him selling her out. Now, once again, we see a criminal defense attorney selling out their client. Here is the Nevada case. I know of somebody in Nevada who was charged with assault and battery for defending himself after a violent attack by somebody else. So somebody assaulted him, then he defended himself. He had a witness who saw the other man attack him first, and the law in Nevada is clear that you have a right to defend yourself from an attacker. Here is the Nevada case law regarding self-defense. In State v. Weddell, 117, Nevada 651, the Nevada Supreme Court stated, like the affirmative defense of self-defense, the state bears the burden to prove that the use of deadly force was not reasonable and necessary. In St. Pierre v. State, 96 Nevada 887, 1980, the Nevada Supreme Court stated, accordingly, once the accused raises the issue of self-defense and the record contains some evidence of its existence, whatever its source, he cannot be required to shoulder the burden of proving self-defense by any standard, as self-defense, by its nature, disproves a fact essential to the offense. To shift the burden to the defendant dilutes the state's own due process burden of proving, beyond a reasonable doubt, every element of the crime charged. Kelso v. State, 95 Nevada at 41. Citing Patterson v. New York, 432 U.S. 197. That's a U.S. Supreme Court ruling. Davis v. State, 321 P. 3rd, 867. A person is allowed to use resistance sufficient to prevent an offense against his or her person, and if the resistance is homicide, it is justifiable. If the circumstances were sufficient to excite the fears of a reasonable person. See Culverson v. State, 106, Nevada, 484. Therefore, we hold that a person who is not the original aggressor has no duty to retreat before using deadly force. If a reasonable person in that position of the non-aggressor would believe that his assailant is about to kill him or cause serious bodily harm. Self-defense is an affirmative defense in Nevada. This means that the defendant has the initial burden to claim that he or she acted in lawful self-defense. Then once the defendant makes his claim, the burden shifts to the prosecutor to prove beyond a reasonable doubt that the defendant did not act in lawful self-defense. And generally, they cannot prove that they have a case that is beyond a reasonable doubt, and they can't present that kind of a case to a panel of a jury and expect to win. In Brady versus Maryland, 373 U.S. 83, this is in 1963, the U.S. Supreme Court was clear that the public prosecutor cannot suppress exculpatory evidence. Now, that is evidence that you are not guilty of a crime. Here's what they said. We now hold that the suppression by the prosecution of evidence favorable to the accused upon request violates due process, where the evidence is material either to guilt or to punishment, irrespective of the good faith or bad faith of the prosecution. In this example from Nevada, the example I spoke of earlier, the criminal defendant defended himself from an attacker and is being charged with a crime of assault and battery. The defendant is still not certain how the public defender will approach the defense, or if the public defender will use the above case law in the defense of his client. I helped this particular defendant with legal research in order to force the issues involved and force the criminal defense attorney to advance a vigorous legal defense, or else resign from the case or be fired. These examples tell us that you cannot always trust your attorney. It is probably valuable to learn something about how to do legal research if you are facing criminal charges and you want to push the public defender to use a more vigorous defense or else get fired. Here are some of your options. You can fire your attorney and defend yourself in the case. This is not a good idea if your command of the English language is not good, or if you have dyslexia, or if you have stage fright, or are otherwise impaired. You can fire the attorney and get a different public defender from the public defender's office to defend you. You can hire a private attorney. Here's how to do legal research. You can go to a law library and look up the exact statutes in the statute law book that you are being charged with. In that section of the law book, there are headnotes and case law that will discuss the many different situations that arise when people who are charged with that specific statute and what viable legal defenses exist. For example, under Penal Code Section 148, you will find all of the reasons and circumstances that exist that will make it impossible or difficult for the prosecutors to prevail against you for interfering with the police or obstruction of justice. That would be in California, by the way, Penal Code 148. You will find headings for each possible situation or legal strategy that arises. You can also find that each state has a law digest. In California, that is called CalJur, C-A-L-J-U-R. You can also do legal research using LexisNexis or Westlaw, which are usually available at most law libraries. You can search these databases by subject, such as suspension of a driver's license without a hearing. There are legal tactics that can be employed by a defendant if he does not use an attorney. That's because the attorneys are somewhat compromised. And we won't go into too much detail, but they can be disbarred for almost any reason. I can discuss some of these here. First of all, you need to avoid signing anything that states you are waiving your right to an attorney. In California, you will see this type of agreement described as a Ferretta waiver. If the judge were to ask you to sign such a document, you could state the following: I do not wish to contract with the court at this time. One of the strongest criminal defense strategies you can use is to state that the criminal complaint or indictment is not signed under oath. This is a common defect in criminal complaints in California and many other states. It's a violation of California Penal Code 959. I have seen criminal complaints in many states, and there are some states that will sign their complaints under oath. However, there are many states that do not do this, including California and New York. In the Fourth Amendment, the second sentence states the following: "No warrant shall issue except upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched or the person or things to be seized." This means that any criminal complaint must be signed under oath. The reason why they do not do this is because the United States government has been in bankruptcy since March 9, 1933, and they are operating under a de facto system of government where they have secretly suspended the American Constitution. They cannot let people find this out or disclose this openly, because it could lead to a lot of demands by the people and eventual criminal prosecution of those who are perpetrating this criminal jurisdiction, this secret jurisdiction. This is documented by a speech on the floor of the House of Representatives by Congressman Trafficant on March 17, 1933. You can look it up in the Congressional Record. It is also discussed in Senate Report 93-549. Here is part of what, and that was from 1973, by the way, the Senate Report 93-549. Now, here is part of what Congressman Trafficant said. "Mr. Speaker, we are now here in Chapter 11. Members of Congress are official trustees presiding over the greatest reorganization of any bankrupt entity in world history, the U.S. government. The case law that supports this legal doctrine, that the criminal complaint must be signed under oath, is from Kalina v. Fletcher, 522 U.S. 118. There are many other U.S. Supreme Court rulings that state that a criminal complaint must be signed under oath. Another case is Ex parte Burford, 7 U.S. 448. That's from 1806. Another legal defense is the Sixth Amendment. When the government charges you with a crime, they have to identify the nature and cause of the accusation. This means what jurisdiction and venue you are being charged under. Most people do not understand this when they read these words, nature and cause. There are 3 criminal jurisdictions mentioned in the U.S. Constitution. These are common law, admiralty, and military law. You may have noticed that there is a gold-fringed flag in the courtroom. This is a military flag. The government cannot admit that they have you in a military court, because then there would have to be a lot of explaining to do regarding the bankruptcy of the United States and the imposition of a permanent state of national emergency that is described by Senate Report 93-549. The gold-fringed flag gives you legal notice of the type of jurisdiction exercised by the court. The way to demonstrate that the court that it is a military flag is by presenting a copy of U.S. Army Regulation 840-10, which is available from the National Archives and probably available online. Section 2-3 at subsections B and C on page 5 of the regulation tells you that the gold-fringed flag is to be used in a military court. There is also an Attorney General's opinion issued about this under the Eisenhower administration. Here is the citation. Attorney General's opinion. See 34 OPS Attorney General 483 and 485. You can get a true and certified copy of this Attorney General's opinion from the National Archives or the Library of Congress. They cannot tell you what jurisdiction and venue is, what the jurisdiction and venue is, but they have to under the Sixth Amendment. Jurisdiction means authority and venue means place or location. I once asked a judge in traffic court if the court was exercising jurisdiction under the original United States Constitution, signed by the Founding Fathers in 1787. The answer came back, "I am sorry, I cannot answer your question." Well, actually, they did answer the question, and you could say, in the absence of an affirmative answer, I interpret your answer as no. I have a copy of a letter mailed by a member of the California legislature where they admit that the gold-fringed flag is a military flag. In paragraph 3, the letter states that the gold-fringed flag is a military flag. In paragraph 3, the letter states that the gold-fringed U.S. flag is used in state and federal court rooms and that this suspends the U.S. Constitution. There it is in black and white. These are just a few ideas for how to deal with a criminal case. There are many other strategies. If your public defender is not using some of the legal strategies he or she should be using, then he or she is selling you out. This is called ineffective assistance of counsel, or throwing the case. You can be used, and this, by the way, can be used as a defense on appeal. There are many other legal defenses that can be used. If you need help with a criminal case, you can contact me here. And thank you for your interest. If you're interested in the book, here's the information on the book on cancer. And thank you.